Is everyone sitting comfortably?
Not yet. Okay, thank you very much to Infotech for inviting me to speak, although I actually think I offered and said I need to speak, because this is something that I absolutely love. I'm passionate about intellectual property. I promise I'm not as boring as that sounds, but I ended up doing a master's in it whilst pregnant with my first child, which in itself shows how crazy you've got to be, really, to then go on and do it. But it's something that everybody thinks they know something about, thinks they know what they're talking about. I get lots of clients ringing me up, like this morning, saying, it's okay, the entire product's branded, they can't take it from me. And I said, right, so you mean it's trademarked? No, we don't have a trademark, but it's branded. Okay, so let's unpick that, and what does that mean? And she thought she had protection already, but as you're going to see, that isn't necessarily the case. So I like to come along and just say to people, here's an introduction. This is not meant to be a comprehensive legal lesson. God knows you'll fall asleep. But it is just meant to be a toe in the water. This is what to look out for. This is what you can do. This is what you can't do. And if you really run into trouble, please give me a call. I'm always happy to have an initial chat. For free. Yes, said that for free. I'm not talking hours, but happy to give you 20 minutes. So yes, feel free. Any questions as well, stick up your hands, happy to be interrupted. And I might well ask for audience participation. You never know. So, managing your brand. You've got a brand, you've got an idea. What can you do to protect it through the law? So you've got apparently you've got three things, but three twice. Copyright, you've got trademarks, you've got passing off, which is not something that's registrable or actually written down in statute. And then I've just put in celebratory endorsement, which I'll mention if we get to time. So copyright, what is it? It's anything that is an original work, i.e. it's new, it's been created by somebody, it's not been copied, and it's in tangible form. So it's not an idea, it's not in your head, it's written down somewhere, hopefully, or it's drawn, or it's on a computer, or it's on the back of a fag packet. It doesn't matter, so long as it is in tangible form, and it's created by somebody. Can't be created by a computer. And a qualifying person is not in bold because I don't want to bore you with it, but it's basically where you're based. So whether or not you come under the British law, English and Welsh law, sorry. So if it is an original work, if it is in a tangible form, and it has been created by a person, you're protected under the Copyright Designs and Patents Act 1988. Fascinating read, genuinely quite interesting. So boring I can be. And that will give you protection automatically. So you create the most fabulous brand name, logo, brilliant, on a piece of paper. That's protected. If somebody else then came into your office the following day, thought, oh, that's good, takes a photocopy, takes it away, copies it, starts to use it, they've breached your copyright. So you can then turn around and say, hang on a second, I'd put that into tangible form, it was original, it was mine, I created it, I am protected under law and I can sue you for damages. So no registration is required, although a lot of people do register with certain organisations like FACT and various others, but you absolutely don't have to. People also pop things into envelopes and stick them through the postal service, so they've then got a start date. Somebody's nodding in the background. Have you done that? Have you got it in a safe somewhere?
I've got loads of just stuff. When I was a student, I used to send it to myself, so it's stamped.
Yeah, so you've got a
3D
start
files
date.
on a CD as well as a letter, so this is my unopened packets.
Exactly. Which actually, there's nothing wrong with that.
I did that too. It
Yeah.
must be a student thing.
Oh, we're all coming out of the woodwork now, the geeks in the room. Excellent, you're in good company. But that's good because you've got a start date. So if somebody says, oh no, but actually I came up with this idea on my own individually 20 years ago, and you can say, well actually 21 years ago I came up with the idea and you were living in the vicinity and you probably would have seen it, and here's my proof. Ta-da! And that's pretty strong proof when you're looking at a court, because they're going to want pretty strong proof if you've got that. Generally speaking, and it will depend on the type of copyright that you're going to have, which I'll get into in a minute, it lasts for 70 years, the life of you as the author, plus 70 years. The only exception to that is the story of Peter Pan, which is owned by the Children's Hospital, Ormond Street. So yeah, and they basically lifted or waived all the restrictions on that because it's such a fantastic money income builder for them, and it's such an amazing cause. So that's the only example I know where there is no restriction, so you cannot ever copy Peter Pan.
Sorry, can I interrupt?
Yes?
Is the author, I mean, in our case, it's people writing computer software.
Yes,
Is
the
the author
author
the
is the
company
person writing
or the person?
Ah, good question. Thank you very much. I'll yes, top of the class. Oh my God, stars on me.
Teachers.
Yeah, keep it up. I'm going to have high expectations now. I'm going to come on to that in a minute. So just to round off, a number of different copyrights can exist in one work. So a song will have copyright in the lyrics as a literary work, copyright in the music as a musical work, and if it's recorded, it'll be protected as a sound recording. So there'll be 3 different types of copyrights with 3 different ways of being breached. So if somebody wrote down the lyrics and copied the lyrics but didn't sing them, they'd have breached the literary work. So it is, when we say copyright, we sort of talk globally, but actually it gets broken down into loads of different parts. So like a DVD film can have copyright in the script, have copyright in the artwork of the DVD player, have copyright in the words of the songs, have copyright in the music of the songs, and so it goes on. So yeah, so it's not quite as simple as that, but generally speaking.
The copyright covers all of those automatically, or you have to register in all of those areas?
No, you don't register anything when it comes to copyright. It's an automatic right that arises as soon as the original work's in tangible form, written by a qualifying person.
So what about the little copyright sign?
Well, I think that was created over God knows how many years ago, but it's probably outside of copyright now because the person who created it, I should think.
But
I'm safe. I'll show you now why I'm safe using that, because I'm using it in an educational capacity. There are certain defences under the Copyright Design and Patents Act that allow you to use things in certain circumstances, which I'll get onto as well. So yes, just to run through, you can have dramatic works, literary works, artistic works, sound recordings, films, broadcasts, and typographical arrangements of published editions. I mean, that's just getting really narrow and anal. Love it. But yeah, if you really fancy a good read, section 1 of the CDPA pretty much tells you everything you need to know. Like I say, it's a great read.
So if a strapline is created,
Yeah, literary work.
for a name of a company, and it's captured as a lockup and printed on a business card, clearly you've got a date stamp there because it was the point at which it was printed.
What's a lockup?
Sorry, so the name of the company, so it might be Joe,
Yeah.
I'm Groovy, so
Yeah.
strapline, yeah. So if you've got Joe and I'm Groovy as a strapline and you kind of pull all that together, it's called a lockup.
Right.
And then if you bang that on a business card,
Well, the point at which it was created in a tangible form, just on the screen, would be your start of the copyright.
so as long as you've got
yeah.
a record of that.
Yeah, or I mean, you don't necessarily have to have a record of it, but don't get me wrong, that is in fact that's great proof. If you're going to get to the stage of going to court, which is the other side of what I do, you would do a witness statement to say, well, I remember that on the 15th of September 1996, I was sat in my chair and I remember the date because, and I created this, and then I spoke to the printers on the 21st, and we then eventually printed it on the 24th. Therefore, I've had copyright in existence from the date I created it, which was, yeah.
Okay.
So breach of copyright. The reason I've got the picture of Jaws there, I figured that we're probably all of an age that we remember that film. Although I was lecturing to some sort of 22, 23-year-olds and I had to explain it. I'm going to have to change my images.
They should see it.
Well, they should see it. Well, exactly. Their education is not yet fulfilled. Sadly, I couldn't show it to them there and then. So to breach copyright, you need to actually copy it. Sounds basic, you'd be amazed how many people forget that bit. It needs to be a substantial part. So the reason I've got the Jaws picture up there is because who can tell me what springs to mind when they think of Jaws?
The music.
Exactly. Dun, dun. So that's basically 2 notes. But there's a whole musical score there. So how much is a substantial part? Well, actually, because that is so distinctive and it's such a massive part of Jaws, and if somebody just did those 2 notes, you'd be like, Jaws. That's deemed a substantial part. So don't think that you can copy something and say, but it's only a page. It's a 300-page book. If it's the page, then actually you're not necessarily safe. So just don't. And also the overall impression of what has been copied. So if you look at the original work, you look at the copying work, does the copying work give an overall impression of the original work? How similar are they effectively? Courts, well, judges, very intelligent people sit there and compare stuff. You know, it's not really. They compare stuff. And ultimately, if you are successful, it can lead to damages. All nice, bit of money. An injunction, i.e. an order from the court saying, you must stop. So the person who is infringing must stop doing whatever they're doing. And obviously there are specifics, they don't just say you must stop. But it will say you need to stop producing it, you need to stop selling it, you need to stop manufacturing it, you need to stop doing whatever you're doing, just stop. And that's a phenomenally strong order. Judges do not like giving injunctions. So to get an injunction, you've really screwed up as the person infringing. And then delivery up, which basically means everything you've created that is an infringement, you give it to them. You either destroy it or you give it to the person who originally owned the work. So you're not going to get to keep anything. And I mean, thousands of things have been destroyed because they are infringing items, which I'll come on to. So just a brief case example. And God, please don't ask me which one was the infringing one and which one was the original, but I think that's the original, I think that's the infringing one. But the point is, one copied the other, and the court, this is the leading case on not only copyright but also on design right, which I'm not going to touch on because it's such a wide area. But you can see there are similarities here. There are the petals and the flowers and the randomness of those. The lines, they're not defined, they are very, they sort of bleed into each other, and this is the same. And the court basically identified a number of components in each one that had been copied, and this is a copy, this is deemed a copy. So it doesn't have to be identical, it has to be, yeah, I know, you're looking and going, really? And this is fabric, it should be in colour.
All the men are going,
Yeah, all the men are going, what is it? All the girls going, oh, I've got that on my curtains. But it's, yeah, the overall impression from this is the same from this.
Can I ask
Yeah.
a question? I know, used to know lots of people in fashion. In fashion, you have to make 3 changes.
Yeah, well,
is it the same in this sort
it's
of
not
thing?
that precise. No.
So you
You
can buy a
can't say
Vivienne
specific.
Westwood jacket. If you change the buttons, the collar, and something else, then you're free to do it. Apparently.
Yeah, I would say that's probably a general rule. As a lawyer, I would never advise
But
that you
it
go and
doesn't.
do that.
It doesn't
Go for
work.
4.
Go for 4 changes. Change the
I
colour.
always advise.
There's nothing that specific that you can rely on,
No.
unfortunately. But I mean, I'll show
They
you.
should
in a
have just
minute.
done the lines the other way. That would have probably made 3.
Yeah, exactly.
The thing is, though, that
We'll make them more.
Or diagonal.
Right, yeah, exactly.
Sorry, I'll say something else as well. Inspiration's everywhere, isn't it? And this person, Margarita, whoever copied whoever or whatever, they may not have ever seen the other piece.
And if you can prove that,
Yes.
you haven't copied.
Yes.
If you can prove that your work is an original work, if you go to
Because you
a
could come
school
up
and
with
an
that,
art
couldn't you,
class,
just one
absolutely.
day, yeah.
You say to an art class, right, everybody draw a bicycle. I mean, all of them are going to have, well, you hope, 2 wheels unless they're drawing us something else.
Penny farthing.
2 wheels, penny, yeah, exactly. But actually, you can have 2 with 2 standard wheels, 2 big, small ones. But they're all going to have the same component parts, one would hope. And so, but they've all been done originally, and that's what somebody really has been done copying. And so they're all original works. They'll all attract copyright. That's fine.
So if this person could have proved that they had
That's what they
had
were
not
arguing.
seen the other
She said,
work.
I haven't been anywhere near it. Don't know what you're
It's
talking
very hard to
about.
prove now, though, isn't it, with the internet? Because
Yes.
you can be
Yes,
in, you
well,
can be in Tahiti and you can go and look
It's
at it.
also even worse if you want to cover a patent. So if you want to, if you invent something and you want to protect it, you apply for a patent. Please always say patent, not patent. Otherwise, the peasant up my neck stand up. Yeah, it's like fingernails on a blackboard. Is that nowadays, if it's in the world, you're deemed to know about it. Well, hell, how on earth? You know, can you be aware of everything? But actually, because of the internet, you're deemed to have done a search and to have actually found as much as possible out about it, and you should have known. It's tough. Again, I'm hoping that everybody might have an idea about, well, maybe not about Vanilla Ice, but there was a song, God.
I cannot imagine what you're going to say. All these three people in the same category.
David Bowie and Queen.
Yeah.
Exactly. Somebody sing at the back. Under Pressure. Thank you very much. An Ice Ice Baby. Queen and Bowie collaborated, brought out a song.
Yep.
Vanilla Ice then sampled it. So he took or copied one of the
Sampled the intro, basically.
It's basically the intro, thank you.
didn't
But he
give
was
them
so
credit.
stupid. He went to an interview and went, no, it's nothing like theirs. Yeah, okay. I mean, clearly with hair like that, he just wasn't thinking straight.
Who's the stupid one here?
Yes, exactly. Well, yeah, come on. Whoa.
Oh,
Yes.
come on.
Different time. So they sued him and they settled. And he got
him for the hairstyle.
Well, I
And
think
he
he should have been
disappeared.
actually. Yeah, copying his image. Now that would have been an interesting case.
For the jacket.
Yes, exactly.
But the intro was
The trousers.
indistinguishable. They were
Yeah,
exactly.
Oh, yes.
Yeah.
Exactly. They
No
were.
idea
They
if songs
were.
can
Without
start
a doubt, you heard it.
Yeah.
And there is a lot of musical copyright
So he
infringement
actually
going on.
tried it. He tried it on. He
Oh
genuinely
yeah,
tried
in
to
an
pass it.
interview that was televised.
I just assumed that was.
That he'd paid for the rights,
for the
No,
rights.
he was
exactly.
that stupid.
My word,
So he
that's
probably, as a
incredible.
result, paid more because he would have been penalised for the fact that he didn't do it in good faith at the start.
If you get it up front, you get a better price.
Absolutely.
You probably thought no one had heard it. 'Cause
Yeah, exactly. Yeah,
Not
they're
very
not that big.
Oh, they were dead. Who are they?
Is that the same as the Procol Harum thing? Who was supposed to have written that and where the
Lighter paid of
underlying
shell.
tune came? Yes.
Quite
That's
possibly.
supposed to be a Beethoven, isn't it?
Is it?
The
Well,
underlying
again,
theme,
is it still
etc.
within copyright?
Well,
Because if the author's dead and 70 years has gone by, you're fine. You can copy it. So hence, a lot of the Shakespeare plays are rewritten these days.
Weren't
Because
the
obviously Shakespeare is no
Beatles
longer
trying to
within
change
copyright.
that?
Sorry?
Weren't the Beatles trying to change that because
Copyright rules.
Yeah, aren't they coming up to that? They want to extend it. I'm sure I
think
read
that's Cliff
somewhere
Richard.
that they wanted to.
and I'm not claiming to be a fan of it, but I think that's Cliff Richard who was saying
No, that's it. You're
all
branded
his
now.
are coming out, yes.
But no, they've got to be dead then,
Shut
70
it.
years.
Shut it.
People are constantly trying to push the boundaries of copyright. And there was a fascinating case, she says, with the author of the Da Vinci Code.
Mhm.
Did anybody actually hear about the case that
Yeah.
was on behind that, and it tried to delay the film coming out, etc. In that people, 3 authors had written a book called The Holy Blood and the Holy Grail, and they claimed that although it hadn't been directly copied, the themes, and they quickly cobbled together a piece of paper with themes on it, that the main themes of their book had been copied in the Da Vinci Code. And they went to court to try to say there is a sort of a copyright whereby if you've sort of copied the general feeling and you haven't actually just copied bits of a substantial part of our book, that is copyright. And they tried really, really hard to push the boundaries and they failed. And I think they were looking to appeal, and then sadly one of them died, another one got terminally ill, but I think it's still with us, and the other one was like, yeah, not doing this on my own, financially crippling. But it was going on all the time. People are always trying to push the boundaries. Ownership, as you were asking about. So the first owner is the creator, so the person who physically did it. However, if you are an employee in employment, you will not be the creator. Your employer will be the creator, or rather they'll be the owner of what you have created. Although that can be displaced if your employment contract states so. So it kind of, as ever with law, it depends. But your first starting point is the creator is the owner. If you're the employer, you will own it. If you've commissioned something, if you as the commissioner ask somebody to create something for you, then it will be down to the agreement you've got with the commissioner and the number of people who don't put in there who's going to own the IPR. I just literally lose count. There's arguments as to who will be the owner, and it kind of, again, it depends on how much you're paying, but I'm trying to think exactly what the law states now because it's just been changed and it's slightly more vague than it was, and I'm not going to go down either way, but yeah, just I'm going to sit on the fence. Yes, it's very comfortable up here. Got
So
a
if
chair.
you're working for a company, you have an idea, you want to, you're thinking about it,
Yeah,
but you might leave,
yeah,
go and do it.
yeah.
Does it belong to you or the company you're working for?
Good question. Do you remember, well, you know chewing gum?
Yeah.
Chap who created that was an employer on the factory floor, I think. Had nothing to do with the development of anything. It was a gum company, it was a glue company, and he used to pick it up and chew it. And yeah.
Sounds ridiculous.
But well, he was cleaning the factory floor. We won't ask about the fumes. And that idea went to his employer. And don't get me wrong, they were very grateful, and I believe they made him like an honorary director or whatever. But he came up with it during company time, and therefore the idea belonged to the company. But if you create something that is completely outside of your sphere of work, you do it outside of company hours, then there is definitely an argument to say it is yours, and you then leave to do it. There is definitely an argument to say that is yours, and it's highly unlikely the company would do it. But,
Or if you had an idea while you were working with one company, you could negotiate that when you left, that idea went with you, no?
yes, I mean, there's nothing to stop you negotiating, or you just want to make sure you're in a position of strength so you can travel all over your employer.
What would you require from your former employer to take that idea with you? Say, for example, you came up with something and they're happy for you to have the rights to it. What would you need from them?
I would think it would depend. If they were trying to claim actually they owned it, you'd want to have an assignment of the intellectual property, which is basically a contractual document which both parties sign that says assignment of IPR, intellectual property rights, and then details exactly what they're being assigned and the rights that go with it. If they're not claiming ownership of it and you own it, I would think you probably want to have some sort of contractual agreement, a contract basically, just saying that we agree X that has created this, he owns all the intellectual property in it, but it's not actually being signed because we're agreeing that he is the creator, he is the author, and he is the owner, and we're happy for him to exploit that in any way he sees fit as the owner. So something along those lines. So if you do breach copyright, what can you say to the court to say actually it's all right? You've been researching something and it's a research document, it's a private study academically, although you can't photocopy whole books. I think it's only a couple of chapters because we all got told that when we were at university, you mustn't photocopy whole books. It's in the public interest, so that's what a lot of yeah, exactly. Yes, and also journalism. Libraries, fair dealing, and incidental inclusion. So you've only put in a little bit. Fair dealing. So it's you're not dealing with it in bad faith. I think. I mean, so long as you're just using like a little bit to make an example of something. For example, you're not trying to. It was never your intention to copy. Yeah, exactly. But I have to say, you want to have fair dealing in conjunction with probably something else. It would be quite hard one to rely on. Trademarks. I've got no idea how I'm doing on time, but everyone's still watching. So let me know. Trademarks. A trademark, everyone thinks they know what it is, but basically a logo. It's either the picture or the word. You can get a word mark or a logo mark, effectively. And the function of a trademark is to show where something originates from. So if you've got a tick on your clothing, it comes from exactly. If you've got 3 stripes, I think it is, down the side of your trousers. That'll do, yes. But you all know that, and they are. I mean, again, you take a bite out of an apple and you show it to people, they're all going to think of that.
And sons.
I'm
sorry. I was paying attention.
Wow.
Cliff Richard and Dan Summers.
It's a great picture, isn't it?
But it's a massively powerful tool. So many people set up a business and they concentrate so hard on their logo and their branding, and they don't protect it. For goodness sake, this is something that everybody's going to look at, you hope, and see, wow, I know exactly where that's from. Therefore, that means brilliant quality. That means, great price. That means fantastic, whatever. Everything you've built up and packaged and put into this brand. Why would you not apply to protect that by law? There's the Trademarks Act protects that for you if you do the application to the Intellectual Property Office. So you apply through the IPO. Great website, genuinely great website. If you've got any questions, they've got loads of information on trademarks, patents, and copyright. I think it's www.ipo.org.uk. And if they grant it, it provides protection under the Trademarks Act 94, You renew it every 10 years. They usually do it online and they'll email you. There you go, I even said it there. So example, you can, baby dry was permitted for nappies. You usually can't have anything that's descriptive. So dry baby wouldn't be allowed. And then dairy gold was not permitted because it didn't have any dairy content in it. And it was misleading. People try all sorts of things. And FC UK was permitted, but I don't know if anyone remembers when that came out. It was massively controversial.
I thought it was
They're still using
such a low-ball thing to do,
Yeah.
wasn't it?
But oh god, the amount of trouble they had getting that through the trademark office. They went through a lot of objections. So copying a trade, if you breach somebody else's trademark, you've copied it and used it in an identical business. And when you think about business classifications, we're normally talking about these classifications, because that's how you record your trademark. You do it in different areas of business. So chemicals or dairy products or whatever. I can't think. There are 54 classifications, do you think, on that? Or if you create a similar trademark and use it on similar goods, and it might confuse the public as to where the origin of those goods are, you're in breach. If you use a similar or identical logo but on completely different goods, then you're also infringing. And there's also secondary infringement. So you buy something that is an infringing item, you're guilty of secondary infringement. And I've got a case to illustrate that later. Again,
So the Gucci the Gucci handbags you get in Turkey and other
Yeah,
places.
you're not allowed to buy
Thailand.
those.
If you buy
I lost
those,
a fake Fendi bag once travelling,
yeah.
and they can actually,
Take it off.
the airport officials can take them.
Really?
Yeah. If you've got something fake.
Somebody I used to work with
We didn't actually get it
set up a
back.
company doing it. So she's a consultant to companies and helps to identify fake and infringing bags. There are criminal charges that can be brought under the Act as well.
Yeah, you're
It's,
not allowed to sell them at the car boot or anywhere.
No, nothing. It's really cracking area of law actually. Again, injunction, order for delivery up of the infringing items, order to delete the sign from the items if it is just the sign and the items are generic, disposal of the goods or destruction, and damages. So pretty much you get the same thing as the C there of what you get.
So would a big brand like Apple trademark in all 54 classifications, or would they?
Do you know, I looked at their trademarks. They've got several pages of trademarks, and I can't think what classifications they put them in. I don't think they have, because I know that there is a company in China that I think make car parts that are Apple.
Okay, or like a brand like a product brand like Nike, would they just go across the board? Or?
I don't think they would, because it's such a broad range of goods. I mean, you literally are talking about chemicals, you're talking about pharmaceuticals, you're talking all sorts of things. And I think most of those companies would say our main area is clothing, and then we might go out into, the bikes or something like that, but it's rare that they do that much. I think it costs them roughly 1,500 quid to register in 2 or 3 classifications, and that's just one mark. So, and Apple's got lots of different variations on their mark
And that's just one
registered,
country as well.
and that's just one country
As you
as
say,
well.
is that global? That's that
No, that's
No,
just-
that's not global. No. And interestingly, there is a European mark that you can apply for, or you can do it separately by country, which some people do. But then if you want to go over to America or Australia, you then have to apply through their offices there. So this is the secondary infringement case, which I just still find extraordinary. There's a chap who made clothing for ferrets. Seriously? And he bought a bolt of fabric that he quite liked at the local market, and he made some little raincoats for his ferrets. And he then got a letter from Burberry saying, you have been using an infringing fabric to create your product. As a result, you're in secondary infringement of our trademark. We would like to have delivery up of the goods or damages, please. And he went to the press and said, this is ridiculous, how dare they? I don't believe he got very far, because it was pretty much bang to rights. I'm pretty sure the market stall got done as well. But yeah, so it doesn't, you can't remove yourself from it.
Even the ferret looks like it's Burberry colours.
Burberry ferret.
He's so cute. The kids I taught went, what is that? I was like, just never mind. The girls knew this one.
Of course.
Of course, even the boys, clearly. So, Christian Louboutin recently has been in the press because he's kicked up a massive fuss because he's trademarked the red sole of his shoe. It is a specific Pantone red. However, Zara created this shoe with the red sole, and Louboutin sued in Paris courts. And actually, of all the places to do it, the Parisian courts looked at it and clearly went, no, clearly that is a far superior shoe. Nobody's ever going to think that Zara could possibly go against Louboutin. And so actually, Zara got away with it. Of all the places to do it somewhere when nobody knows about fashion.
I mean, it's not like the Louboutin is doing anything that no one's ever done before.
It's not the shoe, it's the red sole that he really objected to.
The red stripe in the back there.
Well, actually, it did go all the way down the sole.
Right.
Sorry, I couldn't find a picture with it all the way down the sole.
It's the coloured underneath.
Yeah.
Was the point, yeah.
Subsequently, he has managed to trademark the red sole with the specific Pantone, but not for a red shoe with a red sole. So long as it's a two-tone shoe, he's trademark covered.
And can you wear the Zara's more than 12 times, because that's supposed to be the life expectancy?
Well, that is a question. Well, funny enough, B&Q did state that tester paints of red paint had gone up by something like 38% because of Louboutin shoes. Everyone's going around painting their shoes.
Nicky the testers.
I'm just,
So you could you could design a new boat, and you could paint the hull of the boat a kind of a specific green, and then no one will ever be able to create or paint their boat
if you can
green.
get it trademarked.
Yeah.
And I think that's the difficulty, because people try to trademark smells, think of perfume. People try to trademark all sorts of bonkers stuff, but colours are so difficult to get trademarked.
But that's what I'm saying, it's madness.
It is, but he's done it. He's done it. But I think because what probably lent weight to his application was the fact that he has got such an identity in the red sole. You ask most women who've got a slight inkling about fashion,
Right, okay.
red soled shoe, Louboutin,
Okay.
and they're like, kill for a pair.
Yeah, just as a turn of phrase, you could say that's the trademark.
It's my Louboutin.
But-
Right.
It's just, everybody knows it, don't they? It's a bit like the Manolo Blahniks in Sex and the City.
Lucky I'm Mrs. Agar, we know what she's
Yes.
doing.
I know what
Zara.
Exactly, yeah. And then
Oh, yeah,
actually,
maybe we try and take Yves Saint Laurent.
they're now doing Yves Saint Laurent, and that the US system takes way longer. So they've got to think about their fashion a bit more.
Right.
There's still the backward caps and the baggy trousers.
They're
So
hardly breaking the mould with any of those shoes. Anyway, they've got to move on.
it's all about the red sole. It's all about the red sole.
They're different tones, aren't they? Different colours.
Yes.
It's different pens.
But-
I'd be worrying about them stealing the shape of my shoe, not just the sole.
Well, that's more of a design right infringement, not a trademark. So, because it
And who
really
did
is.
Louboutin get that shape of shoe from in the first place?
Well, they're going to
Anyway,
argue
because
it's
like
original,
I say,
aren't
it's
they?
hardly groundbreaking, is it?
I'd probably say actually the height of it and the width of it is all, yeah.
It's an industry.
So just briefly passing off, if you can't get something protected under statute, which is obviously very strong, there is the common law solution of passing off, which basically provides protection against anyone copying a mark or a get-up that will lead to confusion to the consumer that will damage the owner of the mark. Again, it arises off use of the mark, not registration, and generally people tend to sue for trademark infringement or passing off, or passing off, because invariably the defence to a trademark infringement case is, well, actually their registration for the trademark should be made null and void, because actually they should never have got it in the first place. So in which case you say, well fine, well if it's made null and void, then actually we're still going to sue you anyway, and we're going to sue you under passing off. So it's always a backup. Penguin biscuits, did anyone remember these puffin biscuits?
No.
They were sold in Asda.
Wow.
Really bright people there. They put them on right next door on the shelf. And don't get me wrong, people rip off the standard products all the time, but there's ripping off and there's just being plain stupid. And they were put next door to each other, people grabbing them, not realising that they picked up puffin biscuits, not penguin biscuits. Lots of complaints because they're of superior quality. And so, yeah, they actually got told by the court though, change your get up, you can still sell the biscuits. You know, make it blue or something and something different, and you can sell it.
Right.
So, but they were ordered to destroy everything that looked like penguin biscuits. Briefly, celebrity endorsement, a really new area of law. It's basically used to protect celebrities against false endorsements, but you have to be sufficiently famous to benefit from it. But it's more to say, if you think that you can just use a photo of a celebrity to promote your business, think again. TalkSport tried to do it with Eddie Irvine, and he had a radio to his ear, and so they just put the TalkSport branding on the radio, digitally enhanced the photo, printed off 1,000 flyers, sent it out to clients for a track day, and he sued because I think at the time he was being paid around 25k a year for an endorsement. And he said, I did not endorse them, I never endorsed them, and they were like, what's the problem? You know, well, he's making money out of himself as a person, his persona, his character. So he's protected now.
Is that where the image rights comes into play?
Yeah, and it's still a relatively new area of law, given that our contract law, main contract law book dates back to about 100 years ago. Then yeah, it's still, there's no definition of celebrity, for example, which in itself makes it quite difficult to prove.
Yeah.
You know, who's sufficiently famous? Define fame. God, let's not get Lady Gaga into it. I'm sure she'll have an idea. So thank you very much. I hope you're all still awake. Any questions? Give me a shout.